Well, taking a look at your top story, Judge Bashir Vally believes that an executive decision made by the president can be reviewed. As per his interpretation, Rule 53 can be used to scrutinize not just administrative decisions, but also executive ones. Interestingly, instead of reading out the rationale, Judge Vally chose to hand it over as a document to the representatives of the DA and President Zuma. Last week, Judge Bashir Vally had ruled that President Zuma must submit records and reasons to explain his decision to fire Gordon and Jonas. Zuma now has until Thursday to hand over any documents which led to his decision on the matter, unless he decides to appeal the judgment. While addressing the concerns over presidential prerogative, Judge Vally said, and I quote, "The executive power to appoint and dismiss ministers and deputy ministers is wide-ranging, but is not unfeathered. The executive power conferred upon the President's office by 91(1) of the Constitution is circumscribed by the bounds of rationality and by sections 83B and C. Vally said the exercise of power must meet rationality. He states that for an executive judgment to be legal, it must be rational. It is to test the rationality that the DA moves this application, thereby justifying the rationale behind the plea."
Today, Judge Bashir Vally provided reasons as to why the president should give reasons to his recent cabinet reshuffle. This follows a decision taken in the courts last week. Now the president has 3 days in order to comply or to appeal the decision. Lemogang Fuke with Judith Diaganyo, ANN7, Johannesburg.
Well, a lot of arguments have taken place between the DA and the president over the ambit of Rule 53. Is it applicable to review an executive decision? Well, let's cross to my colleague Kurapetse Magrobo, who has more to understand how Judge Vally justified the use of the section to order the president to submit records.
There has been a lot of controversy around Rule 53 and whether it does apply to executive decisions. Let's just take a look at how Judge Vally justifies using this rule to order the president to submit the documents. Now, the president relies on the literal interpretation of Rule 53 subsection 1, and therein in fact lies the weakness. Rule 53 was promulgated when the executive decisions were not subject to review. Now, with the enactment of the Constitution and the development of common law since the enactment, the executive decisions are now subject to review. Rule 53 should be applied unless it can be shown that its application would actually lead to a failure of justice. And lastly, there is no contention by the president that it would result in a failure of justice, and hence it has been applied by the judge.
A constitutional law expert, Marinus Wiggers, joins us on the phone line. A very good afternoon to you, sir, and welcome to ANN7. My first question to you, it's Judge Vally's interpretation of Rule 53 to review executive decision relies on precedent and absence of an amendment. Is that enough in a constitutional democracy?
Yes, but look, we're now talking about executive decisions, carrying out the provisions of a law or doing executive things. And in this case, my opinion is that reshuffling of a cabinet is not an executive decision. It's an act of government. It is governing the country. So, yes, executive decisions, the court has every reason and ground to ask for reasons to see whether the executive decision is reasonable, and the president or the executive officer, they have applied their minds to the question. But I'm rather doubtful whether a court can question a governing decision to govern the country. Whether it's good or bad, that we can discuss. We can contest that in Parliament, in the political arena, but not in the courts.
Well, if it is an executive decision, as they have pointed out, there's no disputing the fact that executive decisions must be rational, a point raised by the DA. And what would the criteria be to determine the rationality?
Well, it's pretty clear in the Constitution. It says that such an executive decision has got to comply with administrative justice. Now, administrative justice means exactly that. It's got to be reasonable, it's got to be procedurally correct, and it must be rational. So those are the criteria to judge an administrative act, and it's in our Constitution has been fortified by the Act on the Promotion of Administrative Justice.
And why do you think the court impressed upon the need for records? Isn't the president's reason enough, especially as a reshuffle motivation is generally political?
Yes, it's political. As I said, it's an act of, and I can foresee that there's going to be appeal against this ruling of the court.
And what are the chances of the ruling being upheld should the president choose to appeal it?
Well, as I said, I think the ruling would not be upheld because a court of appeal would say, "But look, this is government. We are not in a position. The courts are not in a position to govern the country. We are in a position to control executive acts, and in certain instances, the Constitution gives us the power to see that the president carries out his constitutional duties. But these obligations are, for instance, to call for a general election, to convene parliament, and definite constitutional obligations. So the president's got those obligations, and that the court can control, the constitutional court. But in this instance, as much as we welcome the ruling, that we know what was in the president's mind, and it seems, from a distance of the judges to be irrational. But it's not for the courts to judge the rationality of governmental acts or to govern the country.
Well, thank you so much to constitutional law expert Marinus Wiegers joining me there on the phone line.